Next, we are going to move to, all right, well, what are the important estate planning documents that everybody needs to know about? Well, you definitely have heard of a will. I think everybody has heard of a will. In the information that I'm going to be sending to you, we're going to be talking not just about a will, but a will with asset protection. So we're not going to dig too deep into that today. So let's just cover what a will is. This is everything you need to know. So what is a will? Well, as you probably know, a will is what takes effect on your death. It says who your family is. It says who gets your assets, and it indicates in what proportion. So that is what a will does. Every estate plan, no matter what it is going to have a will. Virtually every estate plan. So what that means is that, let's say you have a different kind of document that's called a revocable living trust. That is also going to have a will. You know, any kind of estate planning platform that you have, and we will be talking about revocable living trust in a minute. Thank you for getting the glare out of my eyes. I appreciate it. Will have a will. So what do people not understand about wills? What they don't understand is that if your estate plan is set up with a will and there's no other plans in place for what happens when you die, there will be a probate. And everybody, no matter who says a probate, I don't want a probate. I thought a will meant that I avoid a probate. No, it does not. It depends. It depends on what your situation is. What did your attorney set up for you? Or did you do it online yourself? If you did, you've set yourself up for a probate. Frankly, the only way that you can avoid a probate is talk to an attorney who understands estate planning and talk through, well, is there a better way to set up my estate plan so that there is not a probate? Probate is where the will is filed with a court. In Washington, it's a really simple process. But it does involve the court, and it does involve legal fees. Frankly, unless you do your own estate plan, your own estate planning documents yourself, online or free or with low cost, there are going to be fees associated with it. I understand that, and that's what keeps a lot of people from doing things. Plus, it seems like it's overwhelming. One of my goals with talking with you today is to try to make it not so overwhelming. That way people can say, oh, well, I think I can take some action to kind of resolve this nagging thought I have about, I don't have an estate plan, or I didn't think I need one, but I guess I do need them. Or, you know, mine is 20 years old and maybe you should have it looked at. Yes, that's my goal, is that you really, you know, look straight on at what your situation is and what steps you could take. They're not that difficult, but it's up to you to take those first steps. So a will typically will need a probate unless it's set up to not need a probate. A will with asset protection is something that is really important for a lot of our clients. In our state, in Washington, the only way for a spouse to protect money for the surviving spouse is if they do it through a will that has a particular kind of asset protection trust in it. You can't do that through a revocable living trust or through avoiding probate. So in that situation, is probate good or bad? Well, let's say you have a $600,000 estate, you and your spouse. Don't get caught up on the number. 600 is just easy to divide by 2. So if you have a $600,000 estate, the first spouse dies, wouldn't it be nice to protect $300,000, that first spouse's share, in a trust for the surviving spouse, so that if that surviving spouse needs long-term care, nursing home care, or, you know, remarries or whatever happens, that first $300,000 of the deceased spouse will never be subject to loss through creditors, through long-term care costs, through redirection to a new spouse. I mean, there's all sorts of reasons that you might want to make sure that you have an asset protection trust in your will, which means probate. So Let me take a look here. I've got a question going back to durable powers of attorney. Dad has a general durable power of attorney for his wife. The wife has dementia, and he has made the daughter the agent for his durable power of attorney. Good. Sounds like good estate planning so far. Daughter wants to know, does she have the ability to do things regarding his wife or not? This is such a good question. So you have the ability to do things for your dad. Your dad has ability to do things for his wife who has dementia. As a lawyer, what we would look at is, okay, what does the wife's durable power of attorney say? Did it appoint her husband? Yes. Okay. Does her husband then, under that power of attorney, have the ability to delegate things to somebody else? So there is an opportunity to delegate. So maybe dad is simply delegating to you things that he wants you to do on his, in his place for his wife. So the answer is maybe you do have the ability to transact business on behalf of the wife through the dad's ability to delegate to you. Another thing that I would look at is, does the power of attorney say, the wife's attorney, durable power of attorney, does it say, if dad can't act, then somebody else can act? Because if dad doesn't want to act, he can then decline to serve, and then the next named power of attorney in fact, same thing, steps up and they can act. So to answer your question with any degree of certainty or confidence, really need to review both of those durable powers of attorney to see what they say. A really, really good question. All right, I talked about a will. We're going to now talk about a revocable living trust. Everybody, I'm sure, has heard that term, revocable living trust. One of the things that I want you to know about estate planning is you will hear the term trust a lot in different ways. When we say, well, who should you appoint under your power of attorney? I say, appoint somebody you trust. I'm not using that term in the way of revocable living trust. So that's confusing. When you hear the term trust, you'll hear revocable living trust, you'll hear irrevocable trust, you'll hear testamentary trust, you'll hear special needs trust, supplemental needs trust, asset protection trust, Medicaid gifting trust. So all of these terms mean something different. And that is why when somebody says trust, that's just like, okay, let's ask more questions. What kind of a trust is it? And frankly, most people don't even know what kind of trust it is, and they don't know what it says or how to administer it. So let's kind of step back a moment. Revocable living trust, what is it? It is a trust. Okay, what's a trust? A trust is a legal document that is signed that says that this legal fiction, so to speak, can manage assets through its trustee. So let me give you an example. Let's say I create a revocable trust. I am the grantor or the trustor. I'm the one who signed the document. Well, I want to be the trustee because I want to manage my own money until I can't. So I am the trustee. And guess what? It's all for my benefit. So I am the beneficiary. I wear all hats when it comes to a revocable living trust. And if I change my mind for whatever reason, I can say, I don't want this trust anymore, and it goes away. So that's one reason for confusion. Why did you have this trust in the first place? The reason that you had this trust was because you said, I want to avoid probate. A revocable living trust, if done right, will avoid probate. So I want to avoid probate. I want to make sure that my house goes to my kids and they don't have to do a probate. Okay, so I set up the revocable living trust. I need to do a deed where I transfer the title of my house from me to the trustee, who is me, so me as trustee. And then on my death, my house then goes to my kids, because they're now the next beneficiaries of the trust, and one or both of them will be the trustee, so they can sell the house or do whatever they want with the house, all without the need to go to a lawyer or to do a probate. And so people really like this idea because they can do it themselves. And that's where people get into trouble, because when you try to do legal stuff yourself, you don't understand what you don't understand, don't know what you don't know, and you can get into problems with it. Revocable living trusts, I would say more often than not, when clients bring them in, it's clear that they didn't understand it, or what the consequences are of doing it, or how somebody would administer it after them or when they're gone. And so basically they were told, hey, this is your end-all solution, just get a revocable living trust. They do that. They can, get them fairly inexpensively, either themselves or, $1,500 to $2,500 or so for the trust. And they feel like, okay, this is cheap, this is good. And they don't get any legal counsel or legal advice, and they don't know what is going to go on with the trust. So that's one of the problems. I do want to point out, as you can see on my screen here, that in Washington, revocable living trusts provide no asset protection for a surviving spouse. So if you wanted to make sure that when you go, your spouse can have money and it won't all be spent on a new spouse or on creditors or, financial exploitation, or some kid, twisting his or her arm, or more importantly, long-term care. We see this a lot. You're likely not going to want to use a revocable living trust type platform for your estate plan. And by the way, if you do have a revocable living trust, you know that you also have what's called a pour-over will. What is a pour-over will? Why is it called that? A pour-over will is intended to capture all the assets that you forgot to put in your trust because you didn't know, and the lawyer didn't help you, or they helped you way back when, but 10 years have gone by, you opened up a new bank account, or you bought a new house, you didn't put it in the trust. So the pour-over will means that on your death, there will be a trust administration, but first there'll be a probate to capture all the assets you didn't put in the trust that you should have. They'll go through probate and they will pour over into your trust. So basically you tried to avoid probate, but you ended up having a probate plus a trust administration. So revocable living trusts, don't get me wrong, they serve their purpose and can be a very good estate planning tool. But I think more so with a revocable living trust than any other kind of estate planning type platform you have to understand it. You have to understand what you need to do with it, what you're giving up, how it works, and involve those people who will be the successor trustees. And I would say, talk to a lawyer when you don't know what you're supposed to do. You should be able to go back to that attorney that helped you with that revocable living trust, and you should expect responsive, helpful action. Will they charge you? Probably. I mean, that is the trade of attorneys, is that we charge for our advice, for our time, for our services. And that's one of the reasons people don't want to go back to lawyers. But if you want it to work correctly, go back to the attorney that drafted it and expect that they will help you, because that is what they should be doing, in my opinion.